We'll now address Reese Richards versus Public Employees Relations Board and Government of the Virgin Islands Police Department. Proceed.
Thank you. Good morning, Justices, and may it please the Court. I also want to congratulate...
I'm sorry, speak into the microphone and please state your name for the record.
I'm sorry, Your Honor. Ryan Stutzman for Reese Richards. And may it please the Court. I also wanted to congratulate Justice Willocks. I was hoping to be the first argument today so I could say that in perpetuity, but I lost that to Attorney Beckstead. But
thank you.
I'm here today. This case is about Title III Virgin Islands Code Section 530, which I think some, if not all of you, are familiar with, provides a procedure for the certain VI government employees to contest adverse employment decisions, and that's by appeal to the PERB. In this case, my client was suspended in 2004, and she did not receive the due process that she's entitled to under Section 530 because the PERB decided that it didn't have jurisdiction. And the Superior Court affirmed that decision. In so deciding, PERB and the Superior Court, just using a colloquial term, pulled the rug out from about 40 years or more of settled understanding of what the purpose of Section 530 is, which was and is to give employees an avenue to contest adverse employment decisions. All the way back to 1958, if not before, the courts of the Virgin Islands have been applying Section 530 to provide this avenue for Virgin Islands employees to contest these adverse employment decisions. And the case that I found back from the 50s is Felix versus Government of the Virgin Islands. And that's cited at 167 Federal Supplement 702.
Mr. Stutzman.
Yes.
You need to stay close to the microphone.
I'm sorry.
And I also neglected to ask you, how much time do you want to reserve for rebuttal, if any?
5 minutes, Your Honor.
Okay, very well.
And so all the way back to 1958, we have that case applying Section 530 in favor of a police chief back at that time. My client also worked for the police department. Over the years, Section 530 has been expanded, only expanded every time, to WAPA employees in 1973, to Port Authority employees in 1983, to the Government Development Bank and the hospitals in 1999. And all the way to the present day, Your Honors, I don't think there's anyone who would dispute that 530 applies to an employee such as my client in the Virgin Islands Police Department, with the exception that we're looking at in this appeal, which is for the brief life of an amendment that was passed in 2001, and that lasted until 2005, when it was amended again. The government argues that this amendment limited PERB review to employees of certain instrumentalities. Those at the time being the Development Bank, WAPA, Port Authority and the hospitals. But this amendment, you'll see in the joint appendix, put all the legislative history in there, and Senator Canton at the time was trying to correct something that apparently the hospitals asked him to do, which is, I guess some probationary employees had been seeking 530 review.
Well, both PERB and the Superior Court on Review ruled that the statute has a plain and unambiguous meaning, and hence that the PERB had no jurisdiction. You obviously disagree with that interpretation of the statute. So what is your interpretation of the statute?
Yes, Your Honor. I submit that this statute is ambiguous. It's clearly ambiguous because of a couple things. Number one, Your Honor, the statute starts out talking about department heads, okay? And department heads is defined in that chapter 3, or I'm sorry, Title 3. And department heads are the heads of executive branch departments. And
Was that the definition at the time of the amendment of the statute?
I'm virtually certain, Your Honor. And so, furthermore, it says that the department heads under this statute include, and then it lists off some of these instrumentalities. Well, the word includes, Your Honor, has been found to be inherently ambiguous. What does include mean? It's expansive. It's an expansive term, not a restrictive term. And when you look at the legislative history and how this has been applied since at least the 50s, it's always been to give a remedy to employees who feel that they've been suspended or terminated without just cause. And so Your Honor, this 2001 amendment, it was inartfully drafted. It's been, with all due respect to the legislature, it's been kind of...
But why is it ambiguous? You're saying you've mentioned two reasons, but I'm not clear on what your argument really is. You are saying that the term including is not a limiting term, it's an expansive term. That's one of your arguments, right?
Yes, Your Honor.
Ergo, it's an expansive term, meaning?
It's an expansive term, meaning that it's not necessarily limited to those listed instrumentalities, the heads of those listed instrumentalities.
But then, would it not say included but not limited to? Would that not be the phraseology? But once the word included, one can rationally or logically interpret that to be including whatever else is listed. It seems like your argument goes towards the including but not limited to, which would then be expansive. But the including, to me, would suggest only those agencies or instrumentalities that are listed below.
Your Honor, including has been discussed in the recent case of Esperson. That's Atlantic Human Resources Advisor v. Esperson, which is a case actually that the government cited in support of its own argument. And Esperson says that the word including in a statute is, and I quote, necessarily ambiguous and a term of enlargement. So you have to go to the canons of statutory interpretation, which include the legislative history and how this has been applied.
Let's stop there one quick second. Including, yes, expansive. And then you have a list of what else is included. So at the end of that listing, that's it. So yes, including is expansive, but however, the including is specified by statute what is included. Is it not?
No, Your Honor, I would submit that including is a term that from which a list can follow, but does not encompass everything that the statute intends to encompass. And again, Esperson calls that word necessarily ambiguous.
But then statutory interpretation would then state, had the legislators intended to not put a limitation, would have said included but not limited to, which then would support your argument. But the fact that it said including and merely did a listing, and at the end of the listing put a period, does that not end whatever was meant to be included?
No, Your Honor, and I don't think that but not limited to is necessarily follows the word including. I think, in fact, it's under Esperson that but limited to is a superfluous language. Including means including, and there can be other things. And again, Your Honor, when you look back at the history, they added every time that they amended the statute.
I don't disagree with you on that. Since 1961, this statute has been amended several times with the intention of including more and more employees so that more and more employees can have due process. I don't disagree with that. What we're looking at here is the language of this particular amendment to the statute. Both the PERB and the Superior Court, as I indicated earlier, ruled that the plain meaning of the statute precluded the PERB from exercising jurisdiction. You're saying the statute is ambiguous, and hence we have to go to the history of the statute, its intent, et cetera. But we only get to the history if the statute is ambiguous.
Yes, Your Honor. And the other thing I would add is that a department head, which is defined at Section 451 as the head of any executive department, it doesn't make any sense to say that a department head could discharge or suspend or otherwise take adverse action against an employee of WAPA or a Virgin Islands Port Authority. And, you know, I want to add, Your Honor, the case of matter of LOF, where I think it was authored by Your Honor, Justice Cabret, which says that statutes should not be read literally or restrictively, where to do so would defeat the purpose of the statutory scheme and produce an unintendable result. And here we have a statutory scheme which since at least the 50s was used to protect, at least give these employees a remedy or a procedure, and with the construction the government wants to give it now, for that very narrow window of time, Your Honor, would remove that remedy. And then I also want to raise Williams-Jackson, that 52 VI 445, where the exact same issue, at least a substantially similar issue, is raised by Your Honor in Note 5. It looked at the same passage in the same statute and came to the conclusion that, that the statute is meant to protect all Virgin Islands executive branch employees who qualify, not just the listed instrumentalities. The court called it the legislature's obvious intent. I'm putting that in air quotes. The court should do the same thing here. I'm running out of time. I have a retroactivity and waiver argument in the briefs, but I'll save some time to rebut.
Very well.
Thank you, Your Honor.
Good morning, Justices. Assistant Attorney General Sean Bailey on behalf of Appellee Virgin Islands Police Department. Just to address a couple things. in what counsel just said. To the extent there is an ambiguity in 530, that ambiguity is only as to the first part of the statute, as he just stated, including, which is the list of department heads, or in this case, employers, bosses, who can
Attorney
do-
Bailey, would you put that microphone, thank you.
Yes, apologies, Your Honor. So as I was saying, to the extent there's any ambiguity in Section 530, it only applies to the first part of that statute, which is where the legislature has listed the officer, the department head doing the firing. What is not ambiguous is the directive and the explanation as to who qualifies, as to who is being fired, which is employees of the listed instrumentalities in the statute. There is absolutely no ambiguity there. The meaning is plain, and therefore there is no need for the court to resort to legislative history. Williams-Jackson as well, which was mentioned, that case dealt with a different version of the statute and a word that was left in the statute, evidently by accident, but most importantly, the Williams-Jackson language that counsel was referring to appears in a footnote, was not raised and argued by the parties, and was not critical to the holding of that case. And in that respect, it's dicta and not of precedential value in this case. But I think that the court has covered the issue of the statute itself well. I would like to turn instead to the second argument in our brief, which is based on the idea of judicial estoppel. And that argument is that the appellant has claimed in the past in other cases before the PERB and the Superior Court related to the same events giving rise to this case, that she was in fact a classified and unionized employee covered under the collective bargaining agreement during the relevant time period. And in fact, appellant has obtained a judgment under those terms where she argued that her rate of back pay should be calculated based on her membership in the union and the rates established by the collective bargaining agreement during the relevant time period. She has benefited from that representation to the court to the tune of hundreds of thousands of dollars. And now here in this case, the appellant would have us believe that she was not a member of a union, not covered by the collective bargaining agreement, and therefore subject to relief under 530.
When she was suspended, was the CBA in effect?
No, Your Honor. The CBA was not in effect at that time. However, the collective bargaining unit had been certified.
Why is your judicial estoppel argument not waived?
The judicial estoppel argument is not waived in this case because these are relatively extraordinary circumstances, Your Honor. First of all, the issue was originally brought up before the PERB all the way back in 2004, but given the state of the statute at that time and the fact that PERB was regularly dismissing these types of cases in terms of, or with respect to people before it from all different instrumentalities of the government on the basis that they had no jurisdiction, it seemed clear that the outcome would be that. And so, yes, the government did, the Virgin Islands Police Department did abandon that argument originally before PERB. However, Section 530B does say that in the event of extraordinary circumstances, even things not raised before PERB are not waived. What's extraordinary about this case is that it lasted so long and languished on the docket for so long that in between the original filing of this case, first in PERB and in Superior Court on writ of review, and when it finally came up again before the Superior Court in 2022, a whole number of other cases related criminal PERB matters had come up, been argued, resolved, and decided, including the ones that I am referring to, where Richards represented that she was covered under the terms of a collective bargaining agreement, and this is specifically in terms of a 2004 PERB case, same as the year of the PERB case underlying this matter, and took that to the Superior Court on a writ of review, maintained that position, and ultimately derived substantial benefit from that position on the basis that she was covered by a collective bargaining agreement. Admittedly, that was did not enter into force until 2005. However, Richards herself has taken the position, it's on JA 140, that she was a classified and unionized employee and therefore entitled to back pay under the terms established in that collective bargaining agreement, even though that collective bargaining agreement wasn't signed until 2005 and the back pay in question dates to 2004. So, those are extraordinary circumstances, Your Honor. From the time this case was originally filed, everything that happened in between, the new arguments advanced by Richards in other related matters, the judicial estoppel argument obviously would not have been available until she asserted that position in other matters before other courts. And so only then, in 2022, when this matter came up again in the Superior Court, was all of that history there for the Virgin Islands Police Department to assert this position, make its judicial estoppel argument, and say effectively, Richards cannot have it both ways. She cannot, in one case before the court, suggest, I am covered by the collective bargaining agreement and obtain relief according to its terms, and then turn around in this case a few years later and say, I am not covered by the collective bargaining agreement, and so I should receive recovery under 530.
When did the Virgin Islands Police Department first assert this estoppel argument?
Well, originally, in this case in 2004, in PERB, it was raised. They ultimately...
And when was the next time?
I believe 2022, when this case was resurrected in the Superior Court, when the Superior Court reached out to Richards and asked if she was going to continue prosecuting this writ of review. It was really the first instance since those positions were taken, since those parallel cases were worked out, that the government had opportunity to address this issue in this case. And so really the first possible opportunity to assert judicial estoppel. One last piece on judicial estoppel. I would simply like to read the quote of this court, that the doctrine of judicial estoppel rests on the basic notion that absent any good explanation, a party should not be allowed to gain an advantage by litigation on one theory and then seek an inconsistent advantage by pursuing an incompatible theory. That is effectively exactly what Richards is attempting to do in this case. She's already recovered on the theory that she was covered by the collective bargaining agreement in one case, a related case arising from almost the exact same facts that originated in the PERB in the same year. And yet, here she is coming before the court now saying, no, I should be entitled to recover under 530 because I was not covered by the collective bargaining agreement. Those positions are by definition inconsistent, incompatible, and must be barred by the doctrine of judicial estoppel.
All right, it's, with regard to the first argument, is the Virgin Islands Police Department conceding that the words department head within that 2001 amendment ambiguous?
No, Your Honor. We're not conceding that that piece of the statute is ambiguous. My intention in bringing that up was simply to point out that appellant's argument on ambiguity only applies to one small portion of that statute and not the operative portion of the language that we're really dealing with here, which is which employees of which instrumentalities are covered.
So you're saying that appellant's argument applies to the words department head, that first part of the statute?
As I understand appellant's argument, Your Honor, yes. It's an argument that there is ambiguity effectively as to who can do the firing or the suspension, but not ambiguity as to the person being fired or suspended who would actually be seeking relief from PERB. But regardless, Your Honor, on the topic of the statutory interpretation, in terms of the statute as a whole, there is no ambiguous language that leads us, in this case, that requires us to resolve any ambiguity one way or another, right? Even if the statute is perhaps ambiguous in the abstract as to that word including, in the case before us, that is not relevant to deciding this case. In this case, the part of the statute that we are interpreting is, was the appellant employed by one of the government instrumentalities covered under Section 530? And on that point, the statute is unambiguous that only those 4 listed instrumentalities are covered. This court has in the past, in People v. Todman, this court cited to a Third Circuit case in which called Friedrich versus U.S. Computer Services. In that case, the court said, in interpreting a statute, we must start with the language of the statute itself. Although a statute should be interpreted in a fashion that does not feat legislative purpose, a court may not rewrite an unambiguous law, even if the court does not believe that Congress intended a specific outcome when it drafted a law. The court must give effect to the unambiguously expressed intent of the legislature. And I think that holds true here. The court went on to say there that even if it seems implausible to deny the administrative agency, in this case the Department of Labor, regulatory power to impose labor standards over drivers of vehicles in interstate commerce, the legislature and not the judicial branch of the government has the responsibility to expand the agency's regulatory power. So in this case, Your Honor, appellee submits that the legislature stated its intent unambiguously in the language of the statute itself. There is absolutely no need to take recourse to the legislative history or look for legislative intent. The first step of the first canon of statutory construction is plain and unambiguous language, and if we have that, we need look no further. And that's what we have in terms of the way that Section 530 needs to be applied in this case. If the justices have no further questions.
We have no other questions, so.
Thank you, Justices. I'll rest on our brief then.
Your Honor, Your Honors, just a few points. Number one, there's been a lot of discussion, both here and in the briefs, about what's happened in other matters that is not in the record before you.
Are you referring to the argument of judicial estoppel?
I'm referring to the assertions of counsel that my client litigated some matter and got money. That's not in the record before this court, okay? That's number one. Number two, counsel is mixing up the termination and the suspension matter, which...
Okay, just a minute. So with regard to the judicial estoppel argument, what your argument is that there are no facts to support the argument of judicial estoppel.
That's one of my arguments.
Okay.
Okay, and further, Your Honor, there are several related cases. One is a termination case. One is a suspension case. We're here today on the suspension case only. My client has not been provided any remedy or money on the suspension case. And we need to talk about the timeline of unionization and the CBAs in this matter. my client, there's nothing to hide here about her union status. And that, yeah, she was covered by a CBA. I don't have the date in front of me, but I believe it was sometime in 2005 or 6 that the CBA with the United Steelworkers came into effect. But the Maritime Union decided that they were going to leave the territory, I think in about 2002. And shortly after that, their day-to-day contract expired. So there was no CBA for about a 3-year period of time, give or take. So there is no inconsistency, there is no estoppel, because for a certain period of time, she was not covered by a CBA. She was unionized by the United Steelworkers after they moved in, but the Maritime Union's CBA had expired, and there was a gap with no CBA coverage. Okay, now I want to talk about waiver. As I say in my brief, the way the government has gone back and forth about their positions is pretty astonishing in this case. First, as to the appellant's union status, and I have a chart I think will be very helpful for you, I think on the first page of the reply brief. The government said in 2004 during the PERB hearing, respondent is prepared to retract its objection to respondent's access to PERB because of union membership. We are not only prepared to, we do. So they retracted the position based on my client's union membership. And as you may or may not be aware, the statute says if there's an objection not raised before the PERB, that objection is waived. And so by retracting that position, they've now waived that position. And then later on, Your Honor, now the government is saying that that the statute is ambiguous. Well, Your Honor, in the briefing in 2002 to the Superior Court, the government looked to the decision of Angel v. PERB, which is at 73 VI 89, that's a 2010 Superior Court case, and said that the PERB lacked jurisdiction to hear this matter, but not for its stated reasons in its November 23, 2004 decision. So in this case, again, it's backtracking on saying that the statute is ambiguous. It's saying in this brief that no, we think now that the PERB was wrong. So we want to go back to our union argument. So first they waived the union argument by retracting it at the PERB. Then they retracted their argument about ambiguity to the Superior Court. So I've never seen this in all my years of practice, but it's like this is a double waiver. And they can't go back and forth with their positions like this with no consequences. Thank you, Your Honor.
Welcome. We take these matters under advisement.